You have to be a permanent resident or a refugee for this video to make sense. If you're a temporary resident, or if you're on a work visa, or if you just don't have status, well, you may have to watch a different video. I have another video for you. So, as someone with permanent residence or you're a refugee and you have your removal order, there's a very specific type of legal procedure called an appeal, which I'm emphasizing you have the option to proceed with in this video. If you really want to challenge the decision, that is. So this is not legal advice, this video. It's too general. I haven't met you. So it's a good idea to speak to a lawyer. You can speak to me. You can speak to an immigration consultant, just as long as you're getting the help you need, information you need. So when a person faces deportation, this means they're being asked to leave the country. As you know, the government has given you a removal order. It's an order saying to depart, and the good news is that the removal order can actually be challenged. So let's talk about how you do it. First thing is you make sure you're eligible to challenge the deportation. Okay, are you eligible? And there's really two ways. This is really a question of, are you eligible for an appeal, or are you eligible for judicial review? So these are the two ways: judicial review, appeal. Some people have to challenge the deportation via an appeal. Others have to go with a judicial review. The basic rule to know if you need judicial review or appeal is basically whether you have a criminal record. Okay, so if you have a criminal record, it probably means you need to do a judicial review. Okay, so criminal record, probably judicial review, and if that's the case, you can go to my other video about judicial review for criminal inadmissibility. This video, on the other hand, is about appeals. So I'm just going to now list all the criminal situations when you might have to do judicial review on the screen. Go ahead, take your phone, take a screenshot, take a photo. I'm going to put it on the screen just now. Okay, so that list that you saw, those are all situations where you cannot appeal. You have a really serious criminal record, basically. Okay, so let's talk about the appeal procedure in this video, though. If you're still watching, it means you're facing a deportation, you're a permanent resident or a refugee, and you don't really have serious criminal charges, or at least not the ones that I mentioned on screen. And you really want to fight this deportation, so one thing you can do is an appeal. But we still have to actually be sure that we can appeal. Are you eligible? You have to have some kind of a status, okay? You have to have a status in Canada. So that basically means three things. You could be a permanent resident. You could be on the permanent resident visa. Or you could be a convention refugee or a protected person. And I don't need to remind you, you cannot appeal if you have criminal issues. Okay, so now that we've cleared up that you can definitely appeal, how do you actually appeal? Okay, number one, first thing you have to do, you have to file your notice of appeal. So this is a document that says, hey, I have a problem, listen up. So the notice of appeal just notifies the court of your claim. It's easy, it's quick, it's really not a big issue. And you do this step within, and this is very important, you file the notice of appeal within 30 days. Okay, so you have 30 days to file your notice of appeal. And who do you appeal to? You appeal to the Immigration Appeal Division, the IAD, as they call it. And you have 30 days from when? Well, basically, it's from when you get the removal order. So you can get the removal order in different ways. For example, you were being held in jail and were given a removal order. It's quite a serious situation. Let's say you overstayed your visa, and the Canada Border Security Agency, the CBSA, knows this, and they are angry, so they sent you a removal order in the mail. Or let's say you were in an Immigration Protection Division court hearing, and the board gave you a removal order in the hearing, or perhaps they mailed it to you. Or let's say you were flying on a plane to Canada and you walked up to the Canada Border Services Agency, CBSA, and the border agent, the person working at the airport, gave you a removal order. Okay, so why am I saying all these things? When the removal order arrived, when you got it, when you clutched it in your hands, this could be by mail, the moment the CBSA agent passed you the removal order, it's this moment that is the beginning of when you calculate the time you have to file, okay? And from this point in time, you have 30 days to file your notice of appeal. Okay, so you wait. Now you wait. You filed your notice of appeal, you wait, but you don't really wait because you should do stuff in the meantime. Because basically now you are emailing and speaking with the government, the Crown, to get evidence. You're asking them for documents, what we call disclosure documents. It takes time for the government to do their job, and in the meantime, you are drafting legal arguments because later on you're going to have to file these. You're deciding what the Crown needs to send you for disclosure. This is evidence. And you are trying to quickly spot problems, spot holes in what is provided. And eventually you'll get the disclosure documents in the form of an appeal record. The minister for IRCC, this is a government minister, but really it will be a lawyer representing them. They will send you an appeal record within 30 days, and the appeal record will contain all documents that the decision maker had and the reasons for their decision when they issued the removal order. And so this is the government's position. This is called the appeal record. So now you wait again, and you have some time because there's going to be alternative dispute resolution, ADR, and it's the government who's trying to get along with you in ADR. They're trying to settle. They're trying to find a solution. Hopefully, it will be a solution between you and the IAD board member and the minister to discuss evidence. The board member is basically a judge, but they don't really decide anything. They just sit there and they give opinions. All discussion is off record, okay, so it's confidential, and solutions are negotiated. That's one negotiated settlement. You call this a joint submission. This is everybody shaking hands, being happy, finding a solution. The government, the minister, they concede some points. So that's that settlement. The second option is where the government minister makes a compromise. Okay, they say okay, we were wrong about some things, but we're still not ready to basically give up the case. So that's option 2. There's a sort of a compromise, but it's still going to proceed. And option 3, the minister stands fast and they just reject everything you say. And that's a bit bad. And so they basically say, I don't agree with you at all. I'm not going to compromise, which is not the best. So that's ADR, that's alternative dispute resolution. And the appellant has 45 days after receiving the appeal record, in exceptional cases, 30 days before the hearing, to file their submissions. So that's you. You have 30 days. You have 45 days usually to file your submissions, which are first legal arguments, secondly evidence, and third information about witnesses. Okay, so basically this is called submissions. These are called submissions, and you submit these as a sort of response to what the government wrote in their appeal record. Okay, so now basically you can wait again, and the minister will actually talk to you again. They'll send their submissions, which is a sort of another response. So you can see it's a response to a response to a response. It's basically a conversation, but with a lot of paperwork. Okay, so now we get to the hearing, the trial, the court appearance. Hearing preparation is important. You don't want to make mistakes because courts have procedures, and you just don't want to say the wrong thing. And courts want to run efficiently, so you don't want to look bad. So how do you prepare? How do you prepare for the court hearing? You will basically prepare with your lawyer usually. You'll usually have a lawyer. If you're self-represented, then you may want to speak to someone who can advise you about the court procedure. And you should probably just talk to a lawyer because it's quite complicated, and it will depend on what kind of a case you have. Secondly, you're going to try to find an error of law, fact, or mixed fact and law. So that's basically really complicated legal arguments about breach of principles of natural justice and best interests of the child and humanitarian and compassionate grounds. And the third thing you're going to do to prepare for the hearing is you're going to basically schedule a time with the government and with the court. Okay, you're just going to coordinate a date. Okay, so now you can wait again, and then you'll actually get to the hearing. And at the hearing, you have some more tasks. So the first thing is you're going to outline the basis of the appeal. What are your legal arguments? And you talk about issues with disclosure, with evidence. Are there any issues with the evidence? Secondly, the appellant is sworn in and you examine them. This is kind of like when people say, swear to tell the truth, the whole truth, etc. And then thirdly, the appellant and the respondent provide closing submissions. So these are like conclusions, basically. And lastly, the judge makes a decision. Okay, so they can allow it or they can dismiss it. If the latter, if the judge dismisses, you have 15 days to judicially review. Not necessarily from the day the judge made the decision, but you have 15 days which are counted from when you receive written submissions. And it happens sometimes that appeals are unfairly dismissed. Okay, so people can judicially review. That's possible. Okay, so that's it. That's an immigration appeal, and if you are facing a removal and think it is totally unfair, that is what you do in general. Again, this is very general legal information. It's general information. It's not meant to be legal advice because, look, cases are complicated, and it's important to talk to a real life human being. If they can ask you questions, that helps. And I, for one, am very happy to receive calls and discuss your case. So you can give me a shout if you require assistance with your immigration matter. This has been Ben Cohen-Mierson, immigration lawyer, and whatever stage you're at, I know you will succeed. Okay, so best of luck.